All right. Well, good morning, everyone. My name is Sean McCoy. The name of my company is Federal Employee Benefits Advocates. We're an educational company. We're based in Parker, Colorado, and I've been doing benefit briefings now with federal employees for about 10 years. And during that period of time, one of the issues that came up consistently as I was doing the briefings was questions that centered around divorce. And the more and more I looked into it, the more and more I realized that I needed to provide some educational information available to federal employees so that they can better understand the decisions and the choices that they need to make when they are faced with a divorce situation. Today, we're able to provide this information to the USDA through courtesy of Linda Duncan. She has set this up. And so we'll spend about 50 minutes going through this presentation. We'll have time available at the conclusion of each section for questions. There'll also be a recorded version of this available that will be distributed to all the people that signed up for the program. So we'll go ahead and get started. So the things that we're going to cover today are the benefits that can be affected by court orders, why federal employees are different because of the different types of court order and the benefits that can be dictated. We'll go through how the thrift savings plan is affected. We'll talk about the federal employee health benefits. We'll also cover briefly FEGLI, and then we'll end the day with the roles and responsibilities of each party. So the first thing is what benefits can be affected by a court order. The first thing that can happen is they can divide the CSRS, or the FERS annuity, a refund of the FERS annuity employment contributions. They can also provide a survivor annuity upon the death of the employee. They can permit a former spouse to continue under the Federal Employee Health Insurance Benefits Program. They can also require an employee to cover his or her children under the FEHB, and they can require an employee or retiree to assign his or hers federal employee group life insurance, the FEGLI, to a former spouse and or children. Now, the court order will not bind the parties, not OPM or the agency in the case of the FEGLI. It also can require an employee to name his or former spouse or children as beneficiaries under the FEGLI. It also can require that retirement benefits be garnished for alimony, child support, or for cases involving child abuse. Now, the benefits that cannot be affected by court orders, they cannot make a former spouse eligible for the Federal Employee Dental and Vision Program, the FEDVIP. They cannot make an agency or retirement system enroll an employee annuitant in the FEDVIP for the children, or make a former spouse qualified to be eligible to enroll in the federal long-term care insurance if they are not enrolled at the time prior to the divorce. So why are federal employees different? Well, federal employees are different because in the private sector, the Employee Retirement Security Act of 1974, otherwise known as ERISA, applies to all private sector employee benefits. The term employee benefit plans is an employee welfare benefit plan, that an employee pension plan, or defined benefit, defined contribution plan, or both. Orders that divide ERISA-based plans are commonly referred to as what's known as a QDRO, or sometimes referred to as a QUADRO, but that stands for a Qualified Domestic Relations Order. Now, unlike the private sector, Civil Service Retirement System and Federal Employee Retirement System, FERS, are governed by a separate set of federal laws and statutes and regulations. CSRS and FERS are not governed by ERISA. So an order dividing a CSRS or FERS due to a divorce is what's called a court order acceptable for processing, or the acronym for that is a COAP. So a court order can be issued by any state, territory, Indian court in conjunction with a divorce, annulment, or separation of a federal employee. The court order, the COAP, must meet the regulatory requirements to effect an employee annuity, a refund of employee contributions, and a survivor annuity awarded to a former spouse. Now, to effect an employee annuity or refund, refund of retirement contributions, the court order must specify a CSRS or FERS benefit, expressly state that the former spouse is entitled to a portion of the employee annuity or refund, expressly direct OPM to pay the former spouse directly, or be silent on who the payer is. So as far as the court order acceptable for processing, it must provide sufficient information for OPM to compute the amount that the former spouse's share of the employee's annuity or refund. In the case of an apportionment of an employee annuity, otherwise known as an apportionment, it must specify the type of annuity for the application of the formula, percentage, or fraction. So what happens in this case, this is a situation where the employee retires and begins drawing their annuity. And so this is what's known as an apportionment. So there are two different terms to look at. One is apportionment, the other would be through the survivor benefit.